This week we have a conversation with two shareholders from Wolf Greenfield who have been here at the studio the last couple days as a part of our annual AI program. We just are wrapping up our AI 2025 program and thought that it would be an opportunity to sit down with them, talk to them about what questions they're getting from their clients, what kind of work they're doing, and any predictions to the extent that they can make them, they want to make. So we have with us here Ed Rassavage, who is the co-chair of the program, and we have John Strand, who is also a shareholder at Wolf Greenfield. And John, you were on the copyright panel.
Correct.
Ed, you've been on the patent panels. Why don't we start with just a brief introduction about what you do, who your clients typically are, what types of work you're doing, particularly relative to AI, since that's sort of the topic of the moment that we're here for. And then we'll go from there. John, let's start with you.
Sure. So I've been at Wolf Greenfield for over 20 some years now, and started my career in doing trademark and patent litigation. Did 90% of my work was patent litigation for years, though. About 6 or 7 years ago, I transitioned to doing mostly copyright and trademark litigation. So that's been my dominant aspect for that time. We're seeing AI on my side on the litigation right now, mostly in a monitoring situation. In other words, a number of clients just having us just seeing what's happening with the cases, making sure they know what the big decisions are and where to go for their own risk assessment of, are they going to be a next in line, or what is my liability going to be based on what's going to happen in the marketplace, and watching that. That's a lot of it.
So it's a lot of wait and see, unfortunately,
here. It's a lot of wait and see, and a lot of time just going through the dockets and making sure that we know where the risks are.
Yeah. Okay, well, I want to come back to that and see where the risks are, but Ed, tell us about what you do. You're a patent guy, right?
Yeah, absolutely. I work primarily in patent prosecution. I do some post-grant stuff and litigation support, but I work primarily, I do have a background in electrical engineering and computer science, but I work primarily in the software fields and work primarily with software companies, as well as biotech, life sciences, and these days I'm doing primarily AI, are most of the patent applications that we're filing these days. It is truly a rush to the patent office with some of these AI-related ideas.
Okay, so let's take a step back and start where John, you were talking about the risk. Where do you see the risk? And Ed, I'll ask you the same question, although I think you'll probably look at it from a different lens, perhaps, given the work that you do for clients. But where do you see the biggest risk for your client companies? And if it helps to know, maybe what your client companies you're working with primarily, are they smaller? Are they mid-size? Are they larger?
The companies that have come to us for risk assessments mostly are mid-sized to larger companies that are very data-heavy driven companies that are looking to use AI to enhance their data and extract value from it in some new way. And they're mainly looking at is, okay, what are the tertiary risks I'm looking at of, OpenAI is being targeted right now, but if I use their modeling or them as a back end for whatever I'm going to do with my data, what's my risk assessment coming out of that, and how that's going to happen?
So are they creating their own programs or platforms and leveraging OpenAI? Are they trying to maybe monetize their data, or a little bit of both?
A little bit of both, yeah. And it's just, some of them are, their answer to the first half would be 3 weeks ago they were doing that, and then now they're doing something completely different. So it does change daily of where they're moving with it, and they're just trying to make sure as they're going through is, what have these secondary companies that are just using OpenAI, not actually being OpenAI or whatever the company is out there, what's happening there.
So Ed, what kind of questions are you getting from your clients? Are you getting any risk assessment type questions, or what kind of risk? I think it's probably a little bit different kind of risk they're concerned with.
Yeah, I mean, a lot of the questions that I get these days is, a lot of these companies are looking to implement AI in their companies, and so they're looking for, how do I write my AI policy? How should users be using these applications? How do we evaluate them? What are the risks? And as well as us, we're a firm, and we're looking to use these tools as well. So we're evaluating a lot of the same things: the confidentiality of our clients' data, and we're all trying to benefit from AI, and but we want to do it in a responsible kind of way.
Uh-huh. And I suppose your clients have a different kind of also, I don't know whether you call it a risk matrix or a trying to make sure that what they're doing is something that's proprietary. They're trying to get patents, and they're trying to plant that flag and see where it goes. I mean, talk about how, anything you want to talk about that whole process, but where I would like to specifically go with is, I think one risk that innovative AI companies face is going back to what John said, like the way you're doing it now might not be the way you're going to do it in 3 weeks. And how does one who's an innovator navigate that kind of sudden change? I mean, AI is changing week to week to week. How does that impact the decision to file a patent? What do you want to file on in the universe that's that fast moving? Those kinds of things.
Sure. Well, and I've worked in the software industry for almost 30 years now. And a lot of times when we work with startups and innovative companies, the approach, at least the strategy as far as patenting is concerned, is try to file on everything, at least describe it in the specifications, and see what sticks. Throw it up on the wall and see what sticks. For a lot of small companies, there are a lot of big players in the AI space, so patent protection is important. We just tell folks, file early, file often, and try to file something good. We use a lot of provisionals these days, filing them within the matter of weeks or months, not years. We certainly convert applications earlier and push people to do that. So it's a little bit more aggressive than it was for just typical software companies in the AI realm.
Yeah, because for your typical software company, unless it's a platform-related piece of software, by the time you get to 20 years, it's long gone. It's been probably gone for a decade or more at that point. And I just wonder what's going to happen with the AI, and I think it makes it even more important to strategically choose what you're patenting. I think you got to be patenting your back end, your platforms, your processing, your handling, your security. Maybe not so much this particular use case. Would you agree or disagree?
I would agree. We do pick things that are have a longer sense of time. So like user interface aspects, or say, for instance, an API. If you had a particular API that did something, maybe not necessarily AI related, but some feature that's going to last and persist through the generation of software. So, a good example is just take Microsoft is, a spell checking feature and a graphical user interface feature that underlines a word that's misspelled. That's persisted from earliest days of the application. And so if you can protect some of those little nuggets, you can get a pretty powerful patent portfolio.
Like the pinch and swipe.
Right.
We're all still doing pinch and swipe.
Right.
So those types of things have long shelf lives, long staying power, and it's an exciting time. But so it sounds like, John, what you're doing is helping people avoid outward risk. I don't know how you would characterize it. It's risk from the outside looking in towards them. Is that right?
The way I'd characterize it is basically they see a potential risk, especially on the copyright side of what's happening with the fair use debate right now. Is it actually fair use of all these companies coming in? And if it's found not to be fair use, what's going to be the ramifications if the back end platform I've been using is OpenAI and suddenly they're found to be copyright infringers to the tunes of billions of dollars or whatever it's going to be? And how is that going to affect us down the line, and what is the status of those? And with my data as a company, is it all proprietary? Some of it's a mix of proprietary, some of it's outside the licensing, and there are talks about, how do we redo our licensing contracts so we can do some of the stuff that we didn't contemplate, 7 years ago before this all started.
And how do you do that? How do they? I mean, because during this conference we've talked about, and I have at least laughed. I'll say I have laughed about it. Is some of the really, I think, egregious overstepping by some companies. We don't need to name them, but like they'll have a product and then a change to their click-on agreement happens, and you realize, oh well, if I'm going to continue to use that product, then I've just given up my firstborn son practically. Like they own everything I upload. They can create derivative works. They can use it to train, and it's like, well. For some things, maybe that's not a big problem, but for lawyers thinking about using this, or any business person who has confidential proprietary information, a lot of those things are just non-starters. And as far as I know, most of those big moments in time for larger companies, they get embarrassed, they immediately take it away. But how does that factor into all of this? Because you've got to have the rights to do what you want to do.
Luckily, the clients I'm thinking about when going through this, their data is not consumer-based necessarily. So they're actually getting other data that is created by the business units. So they have much more control of it in the first place. So there actually can be a more open discussion of where it's going and how it's going to be used. And you don't have to worry about getting the consents of 30,000 million people who are signing on your terms of use and click through. Instead, you're just getting okay, this company owns all the microprocessors that is creating the data through GPS or whatever else. Okay, they own it, so they can renegotiate what the terms are going to be of how it can be used, which it's much easier. That you're right that is a huge concern, and I can see it being walked back and consumers concerned about it. But in a business-to-business discussion where you actually do own the data pretty clearly, it's a bit easier.
Yeah, and that's something that's come up here a couple times. We had a panel on data, and they were talking about how if the user does give you information, you have certain amounts of rights that you've gotten from the user, but then you may have, and this surprised me, the panel seemed to suggest that maybe you'll have less rights if you create the information. So like if you go out and they were talking about scraping, and I think certainly if you're scraping, now we have the legal issue about is that copyright infringement, or are you violating a click wrap agreement, terms of use or service that you already agreed to. But if you just kind of create like a dossier on a bunch of different people, there's a different sense of privacy now, because people are putting, like a bunch of lawyers, use an example, put up your email on your website, you put up your phone number on your website, put up your address on your website. Well, that's now public. And so if someone were to go and collect that information about you, there seems to be an evolution of a concern that, well, I didn't want you to have that for that purpose, so delete it. I don't know where we go with that, because it seems like, and I guess why I'm stuttering and stammering here is it seems like in the AI space, everybody has in their mind, this is a problem, very specific set of facts, and then they kind of try and come up with a solution that addresses that, but they leave it open-ended so it could address everything. And a lot of times that solution that addresses maybe a bad actor doesn't really seem to make a lot of sense elsewhere. How do your companies solve for that? Because as we talked about, every legislator, we had a panel talking about legislation and regulation, everybody wants in on this. Everybody sees this as important. Some of the politicians probably see it as an opportunity to distinguish themselves, maybe a little grandstanding. And things are changing, and things are sometimes overbroad, and it's uncertain.
Yeah. Unfortunately, I think the punchline is exactly what you said. It's uncertain right now, and you just have to do your best to try to at least predict 3 years out and see where you go for that, and understanding you're not going to get 10 years out very easily.
Yeah. So what, I can ask both of you this if you have any thoughts on this. What do you think the role of trade secrets is here? Because one of the things in the AI space, it seems that the real valuable information is the data. If you have, the more data you have, the more insights you can gain, and the more reliable your models become, and the more valuable the models become. But it all comes back to the data. And data can be trade secreted if you do it properly. How do you think that your clients understand the importance of trade secrets in this world? Are they starting to clue in? And what is your feeling on trade secrets and how important they are? Maybe Ed, do you have thoughts?
Sure, sure. In software, and as far as patenting is concerned, we're always making the judgment call between patents and trade secret protection. As far as software is concerned, if you can't keep it a secret, certainly it can't be a trade secret. And so that's when we lean towards patenting something or relying on some other type of protection, contractual or what have you. But data is going to be the big valuable thing, and is the big valuable thing. Most of the companies that have taken off in the AI races are big companies that have access to a lot of data. And so I've worked with many companies historically that they may have some great technology, but at the end of the day, their data was the most important thing, the most important asset that the company had. So those companies that can create these huge data sets that are useful for creating these more accurate models is going to be important in the AI age. Certainly to the extent that they can keep it secret, that's certainly an advantage that they'll have.
So, and do your clients appreciate that? I mean, I think that they probably appreciate the importance of data, right? I mean, because it seems like data is king. It's the new bacon, I've heard people say.
Right.
It's everywhere. It's on everything, and it makes everything better. But do they really? I mean, because it's one thing, in my experience, it's one thing to say, oh yeah, this is trade secret. Trade secrets are important. And it's an entirely other thing to have a regime set up so that it actually, if and when it's necessary, really is legally a trade secret.
Yeah, there are some companies, and trade secret protection it's a lot more difficult than people think. I mean, you have to prove up a trade secret. You have to take steps to maintain it as a trade secret. So you really do need to know ahead of time that this is an important aspect that you need to protect, and you need to protect it against not getting disseminated to outside entities, and really take care of that to be able to have it at the end of the day. So a lot of companies do realize that their data is the most important thing. They take steps to protect it. But some companies back into it, and there was one company that I work with. It was an app company that they, checked into certain restaurants and locations, and the patents were interesting. But at the end of the day, it was really the data and the check-ins and the locations and people's behaviors and things like that people were interested in licensing, and that actually proved to be true.
Mm-hmm. Yeah, I've not seen this firsthand yet, but I know for sure that in any trade secret litigation, one of the first things it's going to be is discovery requests on what AI softwares you're subscribing to, and subscriptions out there, and how you're putting your data out there, because that will be an easy argument of, no, you've released it to a third party because you didn't have the right contractual relationship with whoever you're giving your data to for use. So
yeah, well, and not only that, but like even if you have the right contract, once it's not secret, it's not secret.
Right.
Right. So if the other companies that you've given this to, you promise to keep this confidential and secret, and for the eyes of the people that matter only, et cetera, and then they violate that mistakenly or on purpose or intentionally, or they just don't get the importance of it, it's pretty fragile.
Yep.
So so how do you solve for that risk? And is there any insurance out there yet that companies need to know about or should be thinking about, or is it still real early in the game? And
I'm unaware of that. I haven't seen that. I'm sure there are people thinking about that, but I have a feeling that I have no idea if it's out there yet. But I have a feeling people talked about it. But.
Yeah, I'm not sure if they do, but I'm sure like it's probably covered under risk insurance for the company. Everybody's worried about cybersecurity and data breaches, and I think it's probably along those lines, and the seriousness of it is up at that level.
Yeah, in my experience with insurance policies, and it's been a while since I was a litigator, and you had to look at these policies, one to see whether there was coverage or who you wanted to go after, and that sort of thing. Is insurance wants to get you to pay a lot of money, yearly or monthly or quarterly, whatever they're billing you, to cover nothing. So what they do is they write these policies so that there's exclusion, 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 exclusion. So I know that these cybersecurity policies exist. There's data policies, theft and misuse and all kinds of things like that. I just wonder, at the end of the day, with those legacy policies, whether or not they're going to come to the aid of somebody who has some kind of catastrophic AI problem, because I don't think that the policies probably envision that. At least the ones that were written a couple of years ago, and some of these policies last for a while. So it'll be interesting to see how that develops. And I think, and that's sort of the interesting thing about AI, right? This is a full employment act for lawyers. There will be insurance litigators, there's patent litigators, there's copyright trademark litigators, there's the privacy people. We had an antitrust panel, about competition and are you misusing the algorithms and colluding and so forth. As the world gets better, it always winds up being better for the lawyers. And unfortunately, in this space, that's the case, and I think it's the case because of the level of uncertainty. So what do you advise your client? Like is there like a certain things, like if somebody walks into you, like let's say some young person or young group of people have created something really interesting, they're coming to you. They got maybe some early investment, and now they're like, "Hey, well, what do I do? I get the computer and the AI stuff, but this is my first go round at setting up a business. What steps do you walk them through, or how do you help somebody like that in this environment?"
I'll start with that.
Yeah, sure. I mean, typically it's a provisional application, and let's try to describe as much as you can and hope for the best. Other techniques, evaluate all your types of protection that you can get to establish a strategy early. Try not to lose rights. So certainly provisionals, play a factor there. But a lot of these issues relate not necessarily to patents or trade secrets, but a lot of it is contractual. And read the contracts, and you're dealing with developers and dealing with outside providers, that you have to really meticulously see where the holes are, where the right's going, and things like that. And I find that a lot of early stage companies kind of miss some of the details with those. But it does put a little bit more pressure on the contracts and what's being licensed in, what's being licensed out.
And then on the trademark side, actually, when new startups will come out, I've had several times where the companies develop their name through using AI software, ChatGPT or whatever else, give me names for this company, whatever else, and then actually try to quote unquote clear it through ChatGPT or some other major platform to counsel against them doing that as being the final advice. But it's also, there is actually an interesting play right now on also what are going to be the established generic words within this space, and what is actually going to be more ownable as a trademark. Not to throw one of the sponsors here, but IP Copilot. I think you've seen the word Copilot used by others within this space. And
Microsoft has a Copilot
exactly. So terms like that. There's several others I'm sure out there that are they going to become generic terms that are unprotectable, or are they going to become actual owned by one company?
Yeah, and it's interesting because IP Copilot's been around for 7 or 8 years.
Yep.
So they're not a new company to the AI space. They might be new to people just learning about them, but they've been around for a long time, and that is one real risk with trade. So what do you do when somebody comes like with that? How do you advise them in this space? It never even dawned on me that, I mean, we all know that trademarks can become generic, and if they become generic, then everybody can use them.
Yep.
But is there a rule of thumb or general advice you give them to say, maybe think whether this in 3-4 years, maybe even next week, becomes generic?
It's usually to try to avoid the most descriptive terms, which are unfortunately the ones that clients want to use because it describes what they're doing, so you know what they're doing immediately once you engage them as a client or as a customer. But that's the biggest thing, is just anything that's more in the descriptive, try to be as arbitrary as possible in what the name's going to be.
So it's still that same old, the marketing people want to call it food because that's what we're selling. We're selling food. And the IP people want to call it something, completely and totally arbitrary and fanciful and unrelated to food.
Correct, exactly. And the other thing that's happening too is I think it's getting sorted out within the trademark office and otherwise, but there has been this idea of, okay, we're in AI. Okay, well, what specifically are you doing with an AI? Because you can have one person doing something in geospace or whatever else, another person doing it in a large language model for drafting. Those are completely different services, and they can probably share trademarks without confusion in the marketplace. But a lot of people are still kind of viewing everything as AI, and so you can have arguments coming up. Well, there's going to be confusion, but you deal with it by looking at the customer bases, looking at different actual products or services that are being put out there.
Yeah. Now, Ed, how does that work with your clients? Because as we were just talking about, oftentimes in this space in particular, not unique to this space, but software generally, the real interesting thing winds up being what they're able to collect with the platform. Maybe not the innovation that they created that got a bunch of people excited initially to use winds up maybe fizzling out or getting surpassed or becoming yesterday's news. But the insights that are available through the data is incredibly valuable. And sometimes I don't know whether you can really predict where this is going to go. And in a trademark world where you want to be unique and maybe you're okay, well, I have a pizza restaurant and it has this name. I don't really care whether there's a funeral home that has the same name, maybe because it's so different. Although maybe you don't want to name your pizza place after a funeral home parlor, right? But it's so different that you won't have any legal problems, at least. But here, like when you were talking about the insights available of behavior of customers, I would suspect that a restaurant who deals with reservations and cancellations and no-shows would probably, if you looked at using AI, have all kinds of insights that would be applicable, not just to the restaurant world, but to everyone. I mean, like, I would suspect that, like, if there was a thunderstorm or freak rainstorm, like right at 6 p.m., that a lot of more no-shows happen at restaurants at that time than if it happened at 4 p.m. But then that would seem to me to be interesting information that might even be able to be used by governments looking at traffic flow patterns on highways. I mean, this data can be used in so many different spaces. How does the startup company, one, make sure they're staying in a lane that they can handle it first, but two, aren't just handcuffing themselves to that space so that they can't move out of the space if the opportunity arises?
Sure. Well, we deal with that all the time, especially with the early stage startups where they have good technology, but then it might apply to a bunch of verticals. So like it could be used to solve a bunch of different problems. And so, certainly as far as the patent applications, we try to describe the core technology, but we do include all the verticals and, try to anticipate what the next step for the company is. It's like throwing spaghetti up on the wall and seeing what sticks. So I think because of the issues in relation to the patent office, what's going to be patentable, what's not going to be patentable, what can I get protection on, what can I not, it really does, you take the shovel out when you're initially working with these companies and trying to describe as much as you can, including all the verticals and the potential applications. and try to protect the product plus and try to anticipate the next steps and direction of the company. Many times companies do pivots and they say, well, as far as the patent application, maybe they thought idea A, B, and C was really important. And then it turns out product-wise or business-wise, D, E, and F really do. But you really have to describe all of those things when you're trying to form a strategy for protection.
Yeah, yeah. So let me ask you both this question, because one of the things I think some clients want to know the facts, and I'll make the risk assessment. But a lot of clients will say, "Well, what do you think?" So, like, if a client came to you, and John specifically, I know we talked during the AI program about copyrights and fair use, and can you use the training data, or do you need to pay for it, or is it fair use? Is the output of these systems, is that infringing, or is it not infringing? And there's arguments on both sides. As a content creator myself, I've already decided what I think the outcome should be. But when a client comes to you and they say, look, I don't know enough about this space to be able to make the risk assessment myself, how risky do you think this is? How do you think these cases are likely to come out? What do you say?
Well, it's interesting. I mean, there's kind of two questions. I am not. We don't have any. So how the cases are going to come out is a different question for a lot of them than what my clients are looking at, because they're looking at them, using them as tools as opposed to actually doing the scraping of an entire web themselves or whatever else. It's a really difficult question of how these cases are going to come out, and I honestly don't have a good answer. In the sense, I think, as I said yesterday, I do think it does seem like a direct copy, when they're doing the initial scraping of the data from the internet or from your IPWatchdog and downloading it and looking out. I don't know how that's not a copy at that point and how that's not an infringement. And if you're evaluating that at the fair use, it does seem to be an impingement of the commercial rights of, you could license them that, exactly. Mm-hmm. There's no reason if they want that data and they want your expressive writings, they should be able to pay for them, and they should have to pay for them to do it. And so it's, to me, the balance, and this is my personal opinion, not of my clients, not of the firm, of course, right, is I do think it does seem not a fair use to do this type of scraping and use it.
Well, and that's certainly, from the business perspective, the least amount of risk. If you're not doing that without permission or you're paying for it, then you're not really at risk. If you're got agreements, you're taking public data, which you could get 10 terabytes literally of data just from the patent office. The SEC's got terabytes of data, and so there's a lot of. So if you're using public data, all the cases, all the opinions judges ever write, all of this stuff, that's a safe harbor. If you're paying for it, clearly safe harbor. Yeah. And then if you're not, then I guess we don't know for sure, but it does seem to me that that's going to be a hard fair use argument to win from the platform's position.
Yeah, and there are companies out there that are, quote unquote, playing fair by doing the payments. They are negotiating to buy all of New York Times articles for overtime or whatever else.
Well, in Google licensed, I don't know that I would have done this, but they licensed all the Reddit data. Mm-hmm. And that's a huge database. I don't know that it's particularly well-written database, because when you're on the internet, you just type streams of consciousness, and it's not like licensing the New York Times articles, but it is a gigantic database, and Google is paying for it.
Yeah, and I know you've brought up the patents twice as a 10 terabyte data, whatever else. I hope to God, though, that the outputs from ChatGPT will not have claims that are columns long of one sentence. If that's the expressive and the behavior of the pattern recognition, that's going to be horrible results.
Yeah, no, but and it's interesting that you do say that too, because I asked somebody a while back, that does the AI developing. I'm like, why, when I get an answer from ChatGPT, does it sound to me like the computer speaks English as a second language? And the person just looked right at me and he said, because most of what's on the internet is English as a second language. most of it, like there's only, like the U.S., we speak a version of English. The U.K. speaks, originally English, I guess. Australia has a version of English. Canada, part of it uses English. But the rest of the world that speaks English and communicates in English did so after having learned Chinese first, after having learned Spanish first, after having learned French first. So there is way more information available from non-native English speakers. So it's not surprising that the computer, when it responds, it sounds like it's not a native English language speaker. And I thought, wow, that's both good and scary all at the same time. So I mean, that's the level of influence that what these machines are ingesting has. And I don't know, it's just thought-provoking for me, I suppose, where we go from there. But you can really influence your model, your platform, based on what it's ingesting.
Yep.
Yeah. So are you working with any of that kind of client, Ed, where they're building these and ingesting data and so forth? I'm not going to ask you about the copyright side of it. I'm just curious as to what are the legal concerns that go into that, if you know.
Yeah, I mean, I have had some questions from clients as far as kind of, can we use this in our models? Can we use this data? And a lot of it goes down to the agreements and licensing. And, as we heard earlier in some of the panels, that some of these many litigations in relation to copyright and data use, it's going to be solved by licensing, and so it's going to go into one of the safe harbors. Either it's a public database that's available and freely usable, or it's going to be purchased. And I've had situations where we had to contact big companies to get access to data, and surprisingly, some of these big companies will actually talk to you and will license their data. The cost might be prohibitive for some companies, but really to make these models work and things like that, you're going to need data. A lot of them I've seen there have been improvements where some of the AI patents that we've written and filed on create their own data, and because they don't have access to data sets, their systems they've found the need to create their own data. And have created very useful data sets to make their models more accurate.
Yeah, and I think that if I had to predict, I think what we're going to see is we're going to see a small handful of companies that are doing the massive acquiring of data, like for example, a Google-sized company licensing eventually the New York Times, Wall Street Journal, this Harvard Medical, all the stuff, collecting it all. And then, as we were talking about today, a lot of the niche developers within verticals leverage that data that these larger companies have, and then they fine tune it for the application within their little niche. I think that's probably maybe the short term, maybe the intermediate, maybe even a long term solution here.
Yeah, I agree too. And so some of the larger companies that have some of the larger AI models and tools, there is some trepidation by some companies to use those tools because they don't want to expose themselves to some copyright issue. But many of those tools have provided indemnifications to the companies if they use them. Google and some other companies have agreed to defend on those uses. So just to encourage the use of their AI tools.
Yeah. Okay, well, this has been a great conversation. I really appreciate you sitting down with me. Before I let you go, is there anything that you'd like to say, parting thought, or, maybe it's like a word to the wise, to like people who are thinking about getting into this space as in the AI world, as a developer, or, as an innovator, or as a user, what should they be looking at moving forward?
I don't remember any time in the history of patents or IP that one technology has had multifaceted effect from the the copyright, the patent, and data privacy, regulatory situation. So you really have to have your eyes wide open when you go into into creating one of these systems. And but it is an exciting time, and it's exciting time for technology. It's exciting time for lawyers. So,
Yeah, great. John, your thought?
I agree, and I think that with that exactly what you're saying is it is going to take a team to deal with these things. You're not going to find one attorney who's going to have all of the knowledge based in order to protect you from every risk that's happening with an AI right now. You unfortunately are going to have to employ multiple people in order to head off those risks, and hopefully once you've done that, move on.
Yeah. Well, great. Well, thank you guys. I really appreciate it.
yeah, thank you, Gene.